If you're past the age of 55 and you keep a firearm for personal protection, there's something important you need to hear, and almost nobody is saying it out loud. Hidden deep inside federal statutes, state laws, and dusty court opinions are legal protections designed specifically for older adults. These protections don't show up in gun shop conversations. They're rarely mentioned in training classes. Many lawyers don't even think to raise them unless they've handled cases involving seniors before. Yet these protections can mean the difference between walking out of a courtroom and spending the rest of your life behind bars. Most people assume self-defense law works the same for everyone. Same rules, same standards, same expectations. That assumption is wrong. The legal system quietly recognizes something that common sense already knows. Age changes risk. Age changes vulnerability. Age changes how fast you can move, how hard you can fall, how easily a situation can turn fatal. Because of that reality, lawmakers and courts in many states have built in special considerations for older adults. The problem is that hardly anyone explains them in plain language. Start by imagining a typical self-defense case. Someone claims they were afraid for their life. The court asks whether that fear was reasonable. Prosecutors challenge the story. Defense lawyers scramble to show why the decision to use force made sense in that moment. For most people, the burden is heavy. They must convince a jury that their fear was justified beyond doubt. But for seniors in certain states, that burden can quietly shift. In a growing number of jurisdictions, when an older adult is attacked in their own home or inside their vehicle, the law automatically assumes the fear was reasonable. This isn't a suggestion or a guideline. It's a legal presumption. Once a person crosses a certain age threshold, usually 65, the court starts from the position that an intrusion or violent encounter would naturally cause fear of serious harm or death. Instead of the defendant proving fear, the state has to prove the opposite. Picture a late-night break-in. A man in his 70s wakes up to the sound of glass breaking. He confronts an intruder in the hallway. The intruder doesn't display a weapon. Shots are fired. Under ordinary circumstances, the absence of a visible weapon could become the prosecution's favorite argument. But under senior-specific presumption laws, the court recognizes that for an older body, even an unarmed attacker can be lethal. A shove, a fall, a blow to the head can end a life. That understanding changes everything. In one real courtroom scenario from the southern United States, an elderly homeowner faced no charges after such an incident precisely because prosecutors could not overcome that presumption. They could not prove the fear was unreasonable. The case ended before it truly began. This legal protection had existed for years, quietly waiting in the statute books, unknown to most of the public. Another layer of protection appears when age meets physical limitation. Many seniors live with conditions that younger people rarely consider during moments of stress: bad knees, weak hips, limited lung capacity, heart conditions, balance problems. These aren't just medical issues. In some states, they are legal factors. Most people are familiar with the idea that you don't have to retreat from your own home, but fewer know that some states extend this concept further. For older adults with documented health issues, if a person's physical condition makes escape dangerous or impossible, the law may remove any expectation that they attempt to flee, even in public spaces. Imagine a woman in her late 60s who relies on a cane to walk. She's approached aggressively in a parking lot by someone demanding her purse. The law does not pretend she can sprint away like a 20-year-old. Instead, it allows the jury to consider her mobility, her balance, and the risk that a fall could cripple or kill her. In those states, standing her ground is not framed as stubbornness. It is framed as survival. This protection is not automatic, though. Courts rely on evidence. Medical records matter. Doctors' notes matter. Prescriptions matter. A paper trail that shows long-standing physical limitations can transform a courtroom argument. Without documentation, the defense loses a powerful tool. With it, the law acknowledges reality. Medication introduces another quiet safeguard. Many older adults take prescriptions daily: blood pressure medication, pain management drugs, anxiety treatments, sleep aids. After a self-defense incident, prosecutors sometimes attempt a dangerous narrative: the idea that medication impaired judgment. That fear alone has kept people awake at night, worrying that following their doctor's orders could later be used against them. In several states, lawmakers anticipated this problem. They wrote statutes that blocked the prosecution from using properly prescribed medication as evidence of diminished capacity in self-defense cases. If the medication was taken as directed, it cannot be twisted into an argument that the defender was confused, reckless, or detached from reality. The Midwest involving a retired nurse who defended herself against a former partner who violated a protective order. When the prosecution tried to highlight her anxiety treatment, the judge shut that argument down. Prescription compliance became a shield instead of a liability. The message from the court was clear. Responsible medical treatment does not cancel the right to self-defense. This protection disappears the moment prescriptions are abused. Skipping instructions, mixing drugs without approval, or exceeding dosages can undo it instantly. Careful record keeping and strict adherence to medical advice become more than health habits. They become legal insurance. Age also reshapes how threats are evaluated. Traditional self-defense law often relies on the idea of a reasonable person. But what is reasonable for a younger, stronger body is not reasonable for an older one. Some states have explicitly recognized this difference. In those jurisdictions, juries are instructed to consider the defendant's age and physical condition when judging fear and response. The question is no longer whether an average person would feel threatened, but whether a person of similar age and health would. This distinction matters in moments that might look minor on paper: a shove, a push, a sudden advance. For a senior, any of these can result in broken bones, head injuries, or death. Courts have acknowledged that reality. One case involved a man in his 70s who was pushed during a heated argument. He fell, fracturing his arm. Fearing further harm, he fired his weapon. The prosecution argued the force used was excessive. The defense pointed to the man's age, his injury, and the heightened risk of another fall. The jury agreed that what might be a scuffle between younger people became a deadly threat for an older one. Beyond immediate confrontations, the law also offers seniors a way to clear shadows from their past. Many older adults carry old convictions from decades ago, minor offenses that no longer reflect who they are. In numerous states, there are expedited processes allowing seniors to seal or erase certain records. These programs move faster for older petitioners. Courts prioritize them. Paperwork is simplified. In some cases, once a record is cleared, the individual is legally permitted to state they have no prior conviction. That can restore firearm ownership rights and remove barriers to permits. These programs are rarely advertised. They require initiative, filing, follow-up, but for someone who wants to protect themselves legally before danger ever appears, clearing an old record can be transformative. Inside the courtroom, credibility is everything. Juries are human. They bring assumptions with them. Some states quietly acknowledge that older witnesses tend to be viewed as more reliable. In a handful of jurisdictions, jury instructions explicitly mention that age can be considered when weighing honesty and consistency. This doesn't mean seniors are automatically believed. Evidence still rules, but in close cases, this subtle instruction can tip the balance. It frames the older defendant not as impulsive or reckless, but as measured and sincere. One trial involving a retired teacher ended with an acquittal after jurors later admitted they gave her testimony extra weight because of her age and demeanor. The law didn't force them to believe her. It simply allowed them to recognize patterns supported by research. Finally, there is a safeguard that applies when everything else fails. Even when a conviction occurs, some states allow judges to bypass mandatory minimum sentences for older defendants. The reasoning is blunt but humane. A decades-long prison sentence for someone in their 70s is effectively a life sentence. Judges in these states can substitute house arrest, probation, or reduced terms when age, health, and history justify mercy. This discretion is not automatic. Attorneys must request it. Evidence must be presented. But when used, it can mean the difference between spending remaining years with family or dying in a cell. There was a case involving an elderly man convicted after a defensive shooting went wrong. The statute allowed the judge to consider his age and declining health. Instead of imposing the mandatory term, the court ordered confinement at home with supervision. Punishment remained, but it was tempered by reality. All of these protections exist right now. They are real, they are enforceable, but they are useless if no one invokes them. Knowledge changes outcomes. Preparation shifts leverage. Understanding how the law sees age can turn vulnerability into recognition. Self-defense for seniors is not about aggression. It is about acknowledgement. acknowledgement that bodies change, that risks multiply, that fear is shaped by experience and limitation. The law, quietly and imperfectly, has made room for that truth. What matters most is being informed before a crisis ever arrives, knowing what questions to ask, knowing what records to keep, knowing which protections apply and which require proof. In moments of chaos, preparation speaks louder than panic. The rules are not static. Courts reinterpret, legislatures revise, protections appear and disappear with little warning. Staying aware is not paranoia, it is responsibility. For older adults who choose to protect themselves, understanding these hidden layers of the law can mean everything when seconds turn into years.